Prima facie Talaq-e-hasan is not so improper, says Supreme Court. The Supreme Court on Tuesday, August 16, 2022, prima facie observed that the Muslim personal law practice of Talaq-e-hasan is not so improper. Talaq-e-hasan is a form of divorce by which a Muslim man can divorce his wife by pronouncing talaq once every month over a 3-month period. A bench led by Justice Sanjay Kishan Kaul said a Muslim woman has the option to divorce by the process of Khula by returning the dower, mahr, or something else that she received from her husband, or without returning anything, as agreed by the spouses or Qadi's court decree depending on the circumstances. Prima facie, this Talaq-e-hasan is not so improper. Women also have an option. Khula is there. Prima facie, I do not agree with the petitioner. I do not want this to become an agenda for any other reason, Justice Kaul remarked orally. The court's prima facie remarks came while hearing a petition filed by journalist Benazir Hina, represented by senior advocate Pinky Anand and advocate Ashwani Kumar Dubey. The petitioner argued that Talaq-e-hasan and other forms of unilateral extrajudicial talaq is an evil plague similar to sati. Talaq-e-hasan is arbitrary, irrational and contrary to Articles 14, 15, 21 and 25 and international conventions on civil rights and human rights, the petition submitted. It said there should be a gender-neutral, religion-neutral, uniform grounds of divorce and uniform procedure of divorce for all citizens. The petitioner argued that the practice in question was neither harmonious with the modern principles of human rights and gender equality nor an integral part of Islamic faith. Mr. Anand said the apex court, while striking down triple talaq in the Shaira Bano case, did not address the issue of Talaq-e-hasan. She said the practice discriminated against Muslim women as they cannot resort to it against their husbands. Mr. Anand said the unilateral practice of divorce was abominable. The bench, however, said the court has granted couples who cannot live with each other divorce on the ground of irretrievable breakdown of marriage. It asked whether the petitioner was willing to explore this option if the issue of mahr was taken care of. The court said the issue under question was not instantaneous triple talaq or talaq-e-bidat. It repeated that the petitioner could opt for divorce through the Khula procedure. Would the petitioner be willing for a settlement on amounts being paid over and above mahr being fixed? The court asked the petitioner side. Mr. Anand sought time to get instructions. The court adjourned the case to August 29. Ziausalam writes in the Daily Hindu newspaper that 5 years after Supreme Court's triple talaq verdict, petitioners' living life is half divorcees.
Technically married but practically divorced. The women say their husbands haven't accepted them and they cannot remarry either. Shaira Bano's petition against instant talaq by husband Rizwan Ahmad snowballed into the landmark Supreme Court verdict. 5 years after the Supreme Court's 5-judge bench under Chief Justice J.S.K. invalidated instant triple talaq in August 2017, the women petitioners continue to live a life of half divorcees. Technically still married, practically divorced, they enjoy no conjugal rights nor receive any regular maintenance from the estranged husbands. Practically abandoned, the women cannot remarry in the absence of a legally valid divorce. After the verdict, none of the men were visited by law enforcement bodies and told to take back their wives. Further, no arrests could be made for giving instant triple talaq as the Muslim Women Protection of Rights on Marriage Act 2019 came into force long after pronouncement of instant talaq. Says Shaira Bano, whose petition against instant talaq by husband Rizwan Ahmad snowballed into the landmark verdict. My husband established no contact to restore marriage after the judgment. Legally, I'm still married to him. The marriages of the petitioners subsist but the husbands do not want to reconcile. If the women want to remarry, they will have to do khula. All the burden is on women. However, it was not a battle in vain as instances of triple talaq have come down since the verdict.